What happens to a law that was enacted before our constitution came into force, but now clashes with the fundamental rights that are guaranteed under our constitution, whether it gets deleted from the statute book or it remains in force? Welcome to another episode of Understanding Constitutional Law Case by Case. Indian Constitution came into force on 26 January 1950. But even before that, we had some laws that were made by the British colonial government. After the commencement of this constitution, these laws were inconsistent with the new constitutional vision. So, such laws should be treated void from the moment Indian constitution came into force. That's exactly Doctrine of Eclipse deal with. A fascinating doctrine which deals with this exact situation. When Constitution of India came into force, it came with certain set of rights contained in Part 3 of the Constitution called the Fundamental Rights. Article 13 contained in this part reads as, all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, that is Part 3, Fundamental Rights, shall to the extent of such inconsistency be void. Clearly, a pre-constitutional law which is inconsistent with a fundamental right is not void ab initio. Rather, it is considered to be eclipsed by the fundamental right. It goes in a state of dormancy. It becomes inoperative but not dead. Let me explain this. Imagine that you are standing under a street light and somebody walks in front of it, casting a shadow over it. That's what an eclipse is. A shadow, not destruction. Similarly, when Constitution came into force, a pre-constitutional law which was inconsistent with a fundamental right was overshadowed by the superior power of the Constitution. It was put in a kind of constitutional sleep. If inconsistency is removed, then the law becomes operational again. The first case where the Supreme Court explained and applied Doctrine of Eclipse was Keshav Madhav Menon versus State of Bombay, 1951. Mr. Menon was the secretary of People's Publishing House in Bombay. He published a pamphlet titled Railway Mazdoor ke Khilaf Nayi Sazish, for which he was charged under Indian Press Emergency Powers Act 1931. But then, Indian Constitution came into force and it came with Article 19(1)(a) guaranteeing freedom of speech and expression to every citizen. In light of that, Menon argued that his trial should be quashed because Article 13 declares inconsistent laws void. But the Supreme Court held that Article 13(1) it applies prospectively and not retrospectively. It merely eclipses the inconsistent law. So anything which was done prior to the commencement of the Constitution will continue to be governed by the Act, by the inconsistent Act. Next important case is Bikaji versus State of Madhya Pradesh. This case arose from CP and Berar Motor Vehicle Amendment Act of 1947. This act empowered the government to acquire any motor vehicle business, effectively creating government monopoly. Now, after the commencement of Constitution, private bus operators, including Bikaji, challenged this. They argued that it is in violation of Article 19(1)(g), which grants freedom to do any trade or business, and also Article 31, right to property. In 1951, Parliament passed the first constitutional amendment. It added a new clause to Article 19, permitting the state to create monopolies in trade or business for public welfare. So the question before the Supreme Court was, can a pre-constitutional law which became void after the commencement of the Constitution be revived by constitutional amendment which removed the inconsistency? The Supreme Court held that in 1950, the law was not completely wiped out. It was just dormant. There was an eclipse. When, after the amendment, the law allowed the monopoly, eclipse was lifted and the law automatically revived. There was no need for a reenactment. Traditionally, the doctrine of eclipse was applicable to pre-constitutional laws. But in State of Gujarat versus Ambika Mills, 1974, the Supreme Court made a clarification. The expression void in Article 13 Clause 2, which deals with post-constitutional laws, was to be understood in the same manner as in Article 13 Clause 1. So a post-constitutional law which is inconsistent with fundamental right may not be struck down in its entirety. It may continue to exist and operate in those areas where the right is not applicable. With that, we conclude this video. At LiveLaw Academy, our endeavor is to make you understand that the Constitution is a dynamic document, a document which responds to the past, which regulates the present, and which anticipates the future. Thank you for watching. Let the Constitution guide our understanding. This is Rohit Rohila from LiveLaw Academy.